Good morning, everyone. Welcome to another WILMIC Fall Seminar. This is our, I believe, 14th year in a row that we're putting on the Fall Seminar. And I guess from the weather forecasters, this truly is the last day of fall, right? Winter's going to hit tomorrow. So thanks for being here. I want to welcome all of those watching on the web. For those of you on the web, you have links on your screen. Those will give you access to all the written materials. And you also have a link that will provide you access to email, and you can send your questions and comments to us in real time. Our speakers will be happy to address those as they come in, and we pass them on to them. For those of you here in the room, if you have questions or comments, please jump in, raise your hand, and Katya has the microphone in back, and she will come get you. Please wait for her, because then the web viewers will be able to hear your question or your comment. So welcome. This program has been approved for 3 CLE credits, ethics credits, in case you were wondering. So off we go. We're going to talk today about technology, and specifically cyber security, cyber stability, systems. Mary Smith will be with us in the second hour to talk about the e-trust accounting that is relatively new here in the state of Wisconsin. And then our third hour, Pat Mckenna will tell you about web design and web strategies and things like that. In the first hour, we have Art Safran with us. Art is owner of Safran Technology, LLC. It's an independent technology consulting firm for Wisconsin small businesses. Art was the director of computer services at the State Bar of Wisconsin and the chief information officer at the Wisconsin Medical Society. At both of those organizations, he led internal IT strategies, and he also provided members with practical technology advice. Art was recognized for contributions to technology for nonprofits. He was named as the national chair of the technology section of the American Society of Association Executives. Safran Technology Services include planning, budgeting, network design, hardware and software installation, troubleshooting, and training. Art also specializes in mobile computing, providing access to business information anytime, anywhere, and with any device. That covers quite a bit. Mobile computing, supported by reliable, secure, cloud-based services for email, calendaring, and much more. So those are all things I think we need to hear about. Art's going to tell us all about security. He is an avid biker and has raised a lot of money through his biking, and he stays in great shape. I was telling him at dinner last night, my breakfast cereals, including Lucky Charms and Captain Crunch, and he is now going to get me off sugar. So with no further ado, let's welcome Art Safran.
Thank you very much, Tom. It's a pleasure to be back at the State Bar, to be speaking to lawyers, and welcome to the people on the internet. Feel free to update your Facebook posts as we go along. I won't know anything about it. It's just a quick aside. When I first started working for the State Bar, I was hired to videotape the CLE programs, and the way we used to take them around the state was we would videotape them, and I would then load the tapes and a VCR and this giant video projector into the back of a van and drive it from one location to another and another. So we've come an enormous way since then. It's really nice to see. I would like to thank WILMIC for sponsoring and organizing the presentations today, and thanks to the folks in the room for being here. The advantage of being present is that there are donuts, which are not available for download. Today I'm going to be talking about cybersecurity. It's been a lot in the news recently. You've probably heard about a lot of hacks. Some of you may recall we just had an election. And there was a little controversy about emails and some hacking and that sort of thing. So it's really forefront in the news, and it does have an impact really for everybody. So today, my goal is really not to make you experts and to get too much into the geeky weeds about the bits and bytes of preventing attacks, but I'm going to give you an overview so that you have a better understanding of some of the jargon, and I'm going to leave you hopefully with some practical tips that you can implement in your personal life and in your law firms to help prevent and avoid disasters that are related to cybersecurity risks. As we go along today, what I want you to do is keep in mind some of these questions that you see on the screen. Ask yourself, does your firm follow strong security practices? And we'll talk about what some of those things are. Is there somebody in your firm, whether it's large or small firm, that has the role of a security officer? And by that I mean someone who spends their time or some of their time thinking about, are we protected? Do we follow industry best practices to protect ourselves from being hacked? It doesn't mean that you have to have somebody full-time, but there should be somebody who is interested and kind of asks the questions so that you can self-audit and then investigate and implement some better practices. Do you ever do security audits? And some of the materials I've linked at the end of the written materials have links to security audits, so you can do an audit yourself. And there's really nothing fancy about that. It's really asking questions. How do we do things? How do those compare with some best practices? Also, do your employees understand the ways that they can be tricked into providing access to your systems and giving away confidential information? We'll talk about some of those things that you can do, but staff awareness and personal awareness is really important. And then finally, ask yourself as we're going through, do you have the ability, do you feel confident that if your systems are compromised, let's say all your data is erased from your computer systems, do you have a way that you can recover, or do you just pack up and go home? So ask yourself these questions as we go through the presentation today. But before we get started, what I wanted to do is talk a little bit about some more lighthearted hacks that have historically happened on the internet, because not all hacks are bad. Some are kind of funny. So this one is titled the Operation Cupcake hack. There was a website on the internet where terrorists were providing recipes for building bombs, and somebody with a good sense of humor hacked in and substituted the bomb-making recipes for cupcake recipes. So I thought that was a pretty clever thing to do. Then somebody decided to hack into the Lenovo website. Lenovo is one of the major manufacturers of computers in the world. And instead of the standard content on the Lenovo website, they posted photos in rotation of bored teenagers. Don't know, just a funny sort of thing. You probably also heard about the hack that allegedly the United States and Israel perpetrated on the country of Iran prior to the nuclear agreement that was closed, where they reprogrammed the centrifuges to run at high speed and destroy themselves. Well, they also hacked into their desktop computers and programmed them so that in the middle of the night they would suddenly play at loud volume randomly AC/DC's Thunderstruck. That was unknown to me until I found that out yesterday. And then my favorite is the person who hacked into the San Francisco traffic control system and posted warnings of imminent Godzilla attack and caused some consternation in that city. I don't think it actually happened, but I mean the hack happened, but I don't think Godzilla attacked. But I want to talk about some hacks, some attacks that did in fact happen. These are pretty important ones here. You've probably heard of ransomware. Raise your hands if you've heard of ransomware. Ransomware is a perpetration where a hacker puts some software on your system, and the software that gets installed goes out and encrypts all the data that it can find. And after it's done the encryption, it pops up and says, hey, we've just encrypted your data. You need to pay us a ransom. I'll talk a little bit more in detail about that, but the There were a number of cities and organizations around the country, and you can see some of these highlighted on the screen, that major organizations, including police departments, hospital and health systems, and the city of Detroit, were all hacked and had data encrypted so that the hackers then basically said, hey, you need to pay us in order to give you back the key to unlock your data. So some police departments actually had to pay these criminals in order to get their data access back. This can happen to you very easily. Email account hacking. This is the one that you probably heard of recently when John Podesta, his email account was compromised, and his Gmail account was hacked. And I'm going to show you here a simple way that can happen. This may have happened to you. This specific hack here has happened to some of my clients. You get an email from somebody that you trust, purportedly from somebody that you trust, or in fact coming from their account because their account has been compromised. And in this case, you can see on the screen, it's saying, hey, I sent you a confidential document. It's on Google Drive. Almost everybody has a Gmail account. You should access it. So it comes from someone that you trust, so you click on that link, and then it says, well, in order to get access to the document, you need to log in to your account. So pick one of the email accounts. You can see the popular ones that are listed. Let's assume you use Gmail. You pop up and it says, okay, now put in your email address and your password, because you need to prove who you are in order to get this confidential data. You go, well, that makes sense, doesn't it? You know, and I trust this person who sent it. So you put that in, you hit log in to view, and then it sits and it really doesn't do anything, which is pretty common, right? On the internet, you kind of expect that not much is going to happen. Well, in fact, you've just given your login information to your email account to somebody who shouldn't have it. And you have a sinking feeling that this is not going to be a good day. This is exactly what happened to John Podesta. He got a slightly different email that said, your Gmail account's been compromised, you need to change your password. He sent it off to the IT people that were supporting them. They looked at it and they got back to his support person and said, yeah, this is legitimate. Tell John to change his password. And here's the link to change it. They gave him a verified, valid link. For some reason, he chose to go back to his original email with the malicious link, clicked on it, gave away his password, and we all got to hear about his emails. That has a significant impact on our national discourse. So it is kind of a big thing. It's very easy to give away the keys to your email kingdom. And we'll talk about ways to make it, easy ways to avoid that. And the final example I want to give you before I get into the rest of the presentation is one that's very common, and this may happen to you or to some of your staff in your office, or it may happen to you at home. It's happened to my mother-in-law twice, where something pops up on your computer saying, with dire warnings saying, your computer's infected, you've got 6,000 viruses now running a scan, and then you try to click away from it and it just sort of takes over your computer. Has anybody here had that happen? Okay, nobody will admit it. Oh, I had one. And it's all basically a scam to get you to call this number and get your computer fixed. And purportedly you're talking to somebody from Microsoft, but you're not really. And what they do then is say, well, I need to connect up to your computer, let's fix it. They set up a remote session with your computer. They then take control. They're sitting and controlling your screen, logged in as you, and they purportedly run some scans that are fake. They're not real scans. And tell you, oh yes, these are all the infections that you have on your computer, when in fact they're just listing all the files you have on your computer. And then they tell you, we can fix your computer for $400, or one person was offering, they will fix your computer and all the computers you have in your family and at home, and all the computers will ever own in your entire life for $1,200 or so. So that sounds like a pretty good deal. But the scary thing is they're actually controlling your computer. You don't know what they're doing. Typically, they're just trying to get your money. But this can happen to somebody in your law firm if they get something that looks scary like this come up on the screen. So today, we're going to talk about the types of risks that are out there and what the impacts of those risks are in the event that your systems are compromised. I want to talk about recovery, how you recover from those kinds of attacks, or if somebody is able to actually get in. And most of all, the most important thing is we'll spend some time talking about prevention, because that's the best thing that you can do, is to keep this from ever happening. And a lot of that is just common sense and awareness, but there's some things that I hope that you take away today that help prevent any kinds of attacks. One of the risks, I talked about it before, was we call email phishing. Phishing is a funny term, but basically it's an attempt to access information by sending you fake warnings about by emails to try to get you to do something. So typically the technique is social engineering. They're trying to figure out how they can fool you into clicking on something. And so you may see emails that purport to come from someone you know. So in this case, my brother sent me an email that he said, hey, you're sending me these emails. I know they're not coming from you. And clearly, I didn't send them. But you can see that it looks like it came from me. It says, from Art Safran to David Safran. And so it says to him when he looks at it, hey, it's from Art. But in fact, if you look next to my name, you can see the actual submitting email address. It's nothing to do with me. And then there's a link down there that looks reasonable, but you notice it's a .ru, which is Russia. And actually, I looked at the code behind that, and it takes you to run some malicious software. So the link is fake. The trick here is that in your daily life, you get lots and lots of emails. And when you get an email from somebody that looks legitimate and it looks like it's from someone you trust, you don't necessarily look at the details. So lesson number one is read those things carefully, especially when they're suggesting that you click on a link. And very often, the techniques they'll use will be things like you have a UPS delivery, click here for information. Your taxes are being audited by the IRS. It's important that you click here. I'm sure you've all gotten these emails. Any sort of thing, they're much more sophisticated than the Nigerian prince who wants to give you $1 million. So you want to look for the sort of fake from addresses. The impacts, though, are pretty significant because you can end up with giving somebody, as John Podesta did, access to your email. And the person who gets that access can either use it to send on emails to other people or can actually mine your confidential information. So you can have a loss of client confidential information without even knowing it, because they could be logging in without your knowledge. It's possible that also that by providing with a link that you click on, that you could be installing software on your computer that gives the perpetrators access to your networks. And if this compromise, this loss of confidentiality gets out, you could face a PR, a public relations problem, but also ethical issues where you may have loss of client confidential information. I had one client a law firm that lost a laptop, and they ended up buying a year's worth of credit protection for all of their clients. So it cost them a lot of money. But they felt they needed to do that to protect it because they had social security numbers and other things like that were in the emails that than the data that was taken. I talked before about ransomware. Some of you indicated you know what ransomware is, and I talked about it a bit, but it's a very pernicious and evolving threat that can affect you on a personal level, but also in your firms. And essentially, again, what happens is through social engineering, somebody in your firm will get an email and that entices you to click a link. And it can also happen where you go to a website with malicious links that exploit security risks because your system may be unpatched. But the net effect is software gets installed on your computer, and then that software scours your computer and any computers to which it's connected. So if you have a server or a shared folder on a device, it will go out and search those data sources out and then encrypt them. And once your documents and your databases have been encrypted, then you'll get a pop-up that says you've been infected, your data is encrypted. You can get the key to unlock this by paying a ransom, hence the name ransomware, in Bitcoin. So it's much harder to trace the payment routing. And if you don't pay, then they throw away the key. And once that decryption key has been discarded, neither they nor you nor any computer expert can recover that data. It's gone. And the only way that you can recover is from a backup. The evolution of these threats are, particularly when they hit large companies, is they search out now, they're programmed to search for high value targets. So databases are high value because that contains all kinds of very valuable data about customers and clients and things like that. But also just documents, accounting records. Imagine if you lost your billing records for an entire year. So the other thing is that for the larger firms, your IT staff are targets because they typically run their computers with access to more systems, more of the confidential data. So if they can be enticed into clicking a link, then the losses are much greater. You can end up facing interrupted operations, public relations problems, and a loss of business, not to mention the ransom payment, which is probably going to be the least part of your worry. Another risk is hackers inside your network. So you probably remember some of the highly visible attacks. Target, that was a couple of years ago, right before Black Friday, that caused a lot of problems. That was a case where hackers used systems that were installed by some contractors and were able to get into the target networks and steal credit card information, customer data. JP Morgan Chase, Anthem Health Systems, Sony Pictures, which had a lot of embarrassing information stolen. The lists go on and on and on, and you've probably gotten emails that's saying, hey, you should change your password because these things have been compromised, or your credit has been, your name and social security number has been taken. You should, here's free credit monitoring for a year, those sort of things. Some of these attacks then can happen where hackers come into the networks and they lurk around waiting for access to more useful information, more high-value information. They can be there for weeks and months as they scope out ways to connect up, and you wouldn't know that they're there. Typically, again, the way they get access is they fool somebody into clicking a link and installing some software that then phones home essentially to their servers and gives them access to your systems. But think about the data that you have on your computer systems that are confidential client information, credit card numbers, social security, maybe medical record information if you're doing workers' compensation. A lot of confidential data that is accessible. And again, the public relations kind of an issue if that hack, that attack becomes public, you have some worries that way. It can reduce confidence in your services. Physical access to your systems is something that people don't really think about in terms of cybersecurity, but I kind of like to harp on it because, in fact, your law firms are probably, especially modest-sized law firms, are unlikely to be the targets of somebody trying to hack in through your secure systems. But you're very possibly likely to lose data through just the simple things where theft, where somebody comes in and just walks into your office because they see that they can see through the windows their computers, and maybe they're wearing a uniform, looks like the UPS guy or the photocopier guy or the coffee person, and people are busy, they don't notice, and they don't know who they are. They just walk in, and when somebody's not looking, they just pick up a laptop or a smartphone or computer and walk away with that data. It's very simple for people to do that, and again, it's a social engineering technique where people are sort of unwilling and uncomfortable to challenge somebody. So even if you have a very small office, you should have some kind of system where your front desk person knows who the people are that are your vendors and who they aren't. And they should always require proof of identification, or they should be challenged. It's simple systems. You don't have to have anything complex. But if you don't have this sort of thing, it makes it easy for people to steal data. When you recycle computers and you buy a new one, what do you do with them? Do you make sure that the data on those drives is securely wiped, or do you just sell them, give them to high school, or do you give them away to Goodwill and have them recycled? Should make sure that the data on any old systems is securely wiped, so that nobody who gets it has access. Very simple to pull out a hard drive and pop it into an external unit and then read the data off of it if it's not been encrypted or wiped clean. Laptop devices, tablets, these things. Who has a smartphone? Probably a lot of you have smartphones. These things are increasingly entries into your world of data, and they're mobile, they're easily picked up, and they disappear with regularity. You need to be able to manage and track those, wipe them remotely. We'll talk a little bit more about that. And then just dumpster diving. If you put information, confidential data out into your dumpster, do you have a policy and a procedure to make sure that that's shredded so that it's you're not giving away information, because people will go and look for that. You probably heard about the denial of service attack that happened not too long ago. It was earlier in this month, where Netflix and a number of other services were down because of what's called a distributed denial of service attack. A very simple hack was programmed so that millions of little devices on the internet were unknowingly compromised. And what they did was, on the day of the attack, they were told, start sending data packets at high speed to a service called Dyn.com, and that's essentially an internet hub that manages traffic for companies around on the internet, including Netflix and other companies. All of these compromised devices just flooded the Dyn.com servers with data. They were unable to keep up, and they just stopped working. And that happened for hours and hours and hours. They finally put that attack down somehow, and then it started up again. And it turns out that these devices that were hacked were things like webcams, DVRs. You probably have DVRs in your home. They figured out how to get to those and log into them through unsecured logins that you're not even aware of, that these systems have unsecured chips on them with default passwords that are not protected, that they can take over, and these millions of systems were taken over. So now it's what's called the Internet of Things. So that would be webcams, your doorbells that now have video on them, your DVRs, maybe your refrigerator is connected to the internet. A lot of devices that security wasn't built into them. And if hackers are able to get in, then your systems can be hacked so that nothing happens to you, but they're hijacked and used for other purposes. We have a question, but well, you have to wait for the microphone, as Katya does her Phil Donahue.
There's just been news reports that China, because a lot of these devices, smartphones are made in China,
Yes.
that they're installed unknowingly with devices or chips inside of them that track, where you're at while you're using all this information.
Yes, that news just came out this week that certain Android phones had programming on them that sent full text of your texts and other information back to the company that programmed the software. They claim that it wasn't for nefarious purposes, but that sort of thing happens, and that only got discovered sort of by happenstance, that they found that it was there. So these are things that are out of your control, unfortunately. The good news is your law firm is unlikely to be hit by a denial of service attack because you're not a big target. The bad news is we increasingly depend on cloud-based services. Perhaps you use an office, a case management system or an accounting system that's cloud-hosted because that's very convenient and they may be very secure, but these denial of service attacks can impact your ability to access those services. So it can have an outage impact on you, which means you just can't get work done. It's sort of like somebody cuts your internet connection cord. It's hard to then get any work done. The bad thing is that you don't really personally have control over those things. Those are just more global, more societal and industry kind of issues. Anybody remember viruses? Remember back in the days we used to have floppy disks and, oh yeah, check those floppy disks, as that's how viruses get spread. Well, viruses are still out there. They just they just do different things, and they're just a little bit less. I think that hackers have found more effective ways to make things happen. But I put this screen up because it's still important that you have antivirus protection and anti-malware protection, but it's important to understand the terminology a bit. A virus is technically a piece of malicious software that infects your computer, may do something to it, may cause it to run slowly or give away information, but then it not only gets infected, but then it seeks out other computers that are available and tries to infect them, hence the name virus, sort of like the flu. And getting a flu shot or having an antivirus program is your inoculation against most of those. Trojans are a kind of program that tricks you into installing, and very often those will come as extra payload when you download an update for something. There may be a little box that's checked that basically says, hey, I'm going to install the Ask toolbar. When you sort of wonder, where did that toolbar come from, and why am I not using Google anymore? Those are essentially Trojan programs that fool you into installing something. Typically, they're not necessarily dangerous, but they can hijack your ability to do things in ways that you hadn't expected. And then malware is a kind of a general term covering a wide range of malicious kind of programs. Typically, the impact is that it'll install software that tracks where you go on the internet, or slow down your computer, or hijack your web browser and things like that. Typically, there are programs that can get rid of those, and antivirus programs generally tend to try to help prevent those. But often, we as users are guilty of clicking yes or not checking the little check boxes that are checked by default in order to install software. And then one of the motivations of hijacking your search engine or sticking on an Ask toolbar is that those companies get paid by clicks and by advertising. And so if they can steal your eyeballs to some other website, then they can charge or get paid for advertising dollars. Another risk that is out there is unintended disclosure. One of the benefits and curses of modern email software is auto address fill. And so you start to type an address and bloop, it fills in the quickest find or match that it finds. And that can result then in sending an email to the wrong person. It's very simple, very easy to do that. And if you're sending confidential data in your emails, it's easy to send things to the wrong place. And you probably have all had that. I've done it on occasion. I probably do it several times a year where somebody says, well, thank you for that information, but I don't think I'm the Pam that you meant to send it to. And I go, oops. Most businesses, most law offices have a disclaimer and disclosure at the bottom of their emails that go out that says this is intended confidential for the recipient only. If you got it, by mistake, you should notify me and you should delete it. But once you send that information, it's sent, and so the damage can be done. There are some systems that you can get that will scan your outbound email for confidential data. So it will look for patterns like social security numbers and credit card numbers and attachments and things like that, and can pop up and say, hey, it appears you have confidential data here. Do you really want to send it? So that can at least help a little bit to mitigate some of the possibility of inadvertent disclosure of confidential information. There are, I'm sure, other kinds of risks, but I want to move a little bit into recovery. Assuming that you've actually been attacked successfully and you've essentially lost data, you need to be able to recover from a data backup. I am a data backup evangelist, and typically I like to have 2 or 3 different ways that my client's data gets backed up, and that there's some sort of a system that notifies on a daily basis that the backup has either worked or not worked, because I see too many times when backup systems are installed and the backup drive is full and the backup hasn't worked for many months, or there's been a problem with the backup and there's no notification, so that the ability to restore data is significantly impeded. If you are hit by ransomware and all of your data on your computer or your server, your network is encrypted, and you don't want to pay the bitcoins to the rapscallions who've attacked you, who may just decide then to come back and attack you again because they may leave something sitting on your computer. If you pay once, you're a good customer, and they've been really touted for their good customer service. So the only way to recover without paying a ransom is to be able to restore from a backup from the day prior to when you were attacked. And the nefarious part of these ransomware infections is that the infection, the encryption will typically encrypt everything it can get its hands on, including any local data backups. So if you have a backup drive connected to your computer, it's going to find that drive and encrypt the contents of that drive. If that's your backup, then your backup is encrypted. Now you may rotate your backups weekly off-site, but that means you can lose up to a week's worth of data. I like to see law firms have some sort of cloud-based secure encrypted backup, because once the backup has been sent off to an encrypted secure server, then any ransomware can't encrypt what is not on your network. And then you can do a restore from that off-site location if you need to. And you can also set it to back up multiple times each day. But the only way to recover successfully is from a backup. But if you are infected and you realize it, the very first thing is to pull that network plug immediately, because it takes some time to do encryption, it takes time to do damage. As soon as you have something suspicious, just pull that network plug and isolate that system so that you can limit your damage. If you have, we have a question in the back, Katya.
What network plug?
What network plug? The cable that's connected to the back of your computer that connects you to the internet, or the wireless doohickey that connects you to your wireless network in the office? Good
Thank
question. You could hire security experts to try to check out your system after the fact. If the data's been encrypted, there's not much that they can do. They can help you prevent future attacks. The best time is to get some advice up front. You might have to notify customers, clients, that there's been a compromise. That's never a comfortable thing to do, because you might have to pay for some credit protection, and basically let them know that that you've taken steps to avoid data loss. An embarrassing thing that can happen, particularly with one of the emails I showed before, and I've had a couple of clients where this happened. They gave away their email address information based on an email that they received. The perpetrators got into their email account, then sent that same email to the 1,000 people in their address book, and it came from that lawyer, and then deleted all of the contacts from the address book so that they couldn't follow up to contact them. In this case, they didn't appear to steal anything, but it was a pretty awful thing that they had to recover from. Fortunately, it was a Google account, and Google makes it really easy to undelete contacts. So it was a click, and all the contacts were back. Then they just needed to contact their contacts and let them know that they were aware that this happened, and please don't click on that link if they hadn't already. You can get data loss insurance. There are carriers that will protect you. And you need just to be careful what is covered and what is not covered. But I do want to spend the last couple of minutes before we take some questions on prevention. Raise your hands, even you out in the internet. Do you know what two-factor authentication is? Not a lot of people. It sounds pretty geeky. Two-factor authentication basically is something that, this is your homework assignment. When you leave today, I want you to go back to your offices, or during the day today, and I'll be around this morning if you want help, to set up two-factor authentication. And basically what that means is when you log into an internet service like Gmail or Outlook.com or your banking, you put in a username and a password. And if somebody else gets that username and password, they can log in as you. Now, you may get a notification that, hey, somebody tried to log in or logged into your account, but you can't prevent it. Two-factor authentication requires that in addition to your username and password, you get a text or you use an app on your phone that generates a code, and you get prompted to put in that 6-digit or so PIN, the personal identification number or that code, in order to log into your account. If you don't have this device to get that text message or get the PIN, you can't log in. So if you give away your email address and password, somebody gets it, and they try to log in, they don't have your phone, they can't log into your account. That's really, really good, simple protection. And you can authorize your mobile devices and your office computer, home computer, as trusted devices, so you don't get prompted all the time. But I highly recommend that for banking, you always get prompted for two-factor authentication. You never authorize any device. And every financial institution will offer that. Same thing for investment accounts and things like that. So you should do that. And you should do it for your email. You should do it for banking, anything financial, anything confidential. Require that. Require your employees to do that. Everybody in your office, everybody in your life should do that because it can protect you. Strong passwords. We all hate passwords. We all hate changing passwords. There are services like LastPass, Dashlane, and some others that make managing passwords easier. Essentially, you create a master password, and that password lets you get into your password vault. That password vault then contains all of your passwords for various sites, and they can actually generate complicated passwords that are hard to crack. So you don't actually need to know them. They facilitate entry, and they synchronize between your various devices. Typically, they're pretty secure. The LastPass was hacked a year ago, but they said they didn't lose any data. Everything was encrypted on their site. But it's something you should look into. It makes logging into various websites and keep track of all those passwords much simpler. In addition, you don't have to have a little black book of all your usernames and passwords and keep that up to date. You don't have to have Post-its on your computer screen, which I just hate seeing. So that's important. You should use those systems. You should manage your mobile devices. So this is my next next homework assignment. If you don't have password protection on your mobile phone, then you need to activate it immediately. Go into your setup and set up a PIN or a thumb, fingerprint protection. Additionally, if you have employees that have access, and if you have access to confidential information with your phone or a tablet, you should have the ability to remotely wipe it. If it's lost or stolen, the next time it connects to the internet, you should be able to send out a packet that says delete all the information on there, and it will wipe it and restore it to factory defaults. That can help you with lost data. Talked about secure data backup. The next thing is staff training. You should spend some time talking with your staff and making sure that everybody in the office understands the social engineering tricks that hackers will try to use on them. Make sure that you lock down your site security and have some sort of procedure for making sure your offices are secure. There are services that let you send encrypted emails and scan for sending confidential information, as I mentioned. And then consider looking at the link that I have on running a security audit to make sure that your offices or that your use of technology is managed and at least planned so that everybody's aware of how you do things in your office. So to wrap up, and then we'll take some questions. You can't prevent all attacks, but you want to make it harder. You want to think about it, have a plan, make sure you follow your best practices. Need to have your staff aware of how hackers will try to fool them. And you should be reading on a regular basis the press and try to understand the changes and the trends so that you can stay ahead of things. So with that, I would like to open it up to questions. Got a question in the back or over there.
Sorry. I had a question about if a device gets stolen and you have the ability to, I know I have the ability to remote wipe my phone. I was actually at a mediation where someone came in and went and took the mediator's phone and tablet and all of his stuff. Police came up and responded, and he had already remote wiped it, and the officer was irked because he said, I wish you would have at least done locate my device first and then remote wiped it. Do you have any call about that? Is it worth waiting the extra minutes to locate the device and then wipe it, or is the data security more important in that circumstance?
Well, I think in that case you have different motivations. The police want to catch the crook. You want to prevent loss of data. I would be selfish and prevent loss of data because I would be freaked out. And the tablet is just a tablet. There's just a piece of hardware. The data that's on there is priceless. So if you know that your devices are password protected, then perhaps you could wait a little bit, but I would find that very hard to do.
Any preference for password protecting it with your ID fingerprint or number, PIN number?
I think the fingerprint is fine because it's pretty unique. And if somebody wants to kidnap you and force you to, or cut off your thumb or something like that, I think that's pretty unlikely. The most important thing is to make it hard. But I believe that if you're going to set up a thumbprint, fingerprint, it also requires that you have a PIN to be able to get in, typically, so that you have two different ways, because if for some reason the scanning of your thumbprint doesn't work, you need to have another entrance point. So it kind of does both. I think they're both good. Other questions?
Art, before I get to this one,
Sure.
a web question.
Sure.
Are small or solo more susceptible or less susceptible? And how, as a solo, can I afford to do some of this stuff with no IT staff?
Good question. I think everybody is susceptible. The impact is really the same. I think it's just a matter of magnitude in a large law firm. You may be a more attractive target if you are doing high visibility controversial cases where there's motivation to want to get to data. But if you have a contested divorce and you have an unstable spouse who wants to get access to information, they may try to use some techniques to get in. So small and large, I don't think it makes a big difference. Larger law firms probably have IT staff, and they tend to be ones who think that they're invulnerable. So I think that's a real danger point. How can you afford it? Hopefully some of the tips that I've given you will help. Password protection, complex passwords, two-factor authentication, antivirus, anti-malware, being aware. Those are very simple techniques that really don't cost anything that you can implement. And if you have a computer IT person available in your community, you can ask them for assistance to do those basic things. And maybe come in and do a program for your staff on awareness, so that because that's the biggest weakness, as people just get busy and they click.
I don't understand the two-factor authentication, how you get that set up.
Sure, that's a good question. How do you set up two-factor authentication? That's going to vary based on the service. So if you have a bank, you'll log into your account, and they will have probably a place where you can set up two-factor authentication. They'll walk you through it on how to do it. Essentially what you're doing is you're telling the bank for your online account, I want to enforce two-factor authentication for my account, and they will then activate that. And typically then what happens is the next time you log in, and it will say, you register your phone number, your mobile number. It will send you an email, or a text rather. They'll come to your phone, and then you'll punch in that code on the screen when you're logging in. There are also apps that you can put on your phone that will generate those codes, so that you don't need to have texting. And if you're traveling, you can typically print out a set of codes that you can use if you don't have access and you need, like you're in Europe and you don't have access. Google, if you use Gmail, then you go into your account setup, or you just do a search for, like, okay, here's an IT guy's trick. I should not give away the story here. Use Google and type in, how do I set up two-factor authentication for First National Bank? You'll find an answer. Okay, there, I just lost a lot of clients.
Art, we have a web comment. He says that he believes the smaller firms are more likely to be hacked and not know it. He says hackers are going after low-hanging fruit and moving up the ladder.
That's a good observation. I don't have statistics, so I don't really know. The fact is that it's really easy to send out millions of emails. It costs almost nothing. One of the things that happens as a result of the highly visible hacks that you've heard about, Target and the federal government and all of those, is they gather email and contact information, and then they sell that. And that's what's used by the potential hackers. And so they send out millions of emails, and I don't think they're after particularly individuals. They're specific sizes of firms or organizations are after anybody who'll click. And then once they have access, then they can spend time exploring. That's the biggest danger. It's pernicious. It's just very high quantity. If you go into your spam folder and read the emails that are put into that folder, you'll see lots of those attempts to get you to click on links. And so I think it hits everybody. Any other questions? Well, thank you very much. Appreciate the attention and the opportunity today.
Thank you, Art. 10-minute break, and we'll be right back.
That's it, right?
July 1?
July 1st.
July
Yes.
1, okay.
And I think this is the forward clicker, the one where the arrow is worn off is likely to forward.
Yeah, I would think. Should we give it a try?
Sure. Yep.
And then back?
Great.
Okay. Yeah, you're right. Isn't that funny?
Yeah, I figured that would logically be.
Obviously, very, very few people have to go back.
That's a good thing.
Yeah, yeah. Including the most Wisconsin. Get started here, folks. Welcome back. We'll go into hour number 2. This hour, we're going to talk about the e-trust accounting rules. The new rules took effect July 1st, and Mary Haft-Smith is with us this morning. We're happy to have her. She is the Program Administrator of the Office of Lawyer Regulations Trust Account Program. Mary received an undergraduate degree from the University of Wisconsin-La Crosse, followed by training in administrative and public law. She was an OLR investigator for 17 years before taking on the office's trust account program in 1999. Since then, Mary has handled numerous trust account-related investigations, and she regularly presents seminars on trust account management. So we're very lucky to have her here with us today. In addition, Mary has worked with the State Bar, the Wisconsin Bankers Association, the Wisconsin Trust Account Foundation, all in drafting multiple amendments to Wisconsin's trust account rules, including the most recent recreation of the rule that I mentioned that took effect on July 1st of this year. Ladies and gentlemen, Mary Haft-Smith.
Thank you, Tom.
Good morning. It's a pleasure to be here. Thank you to WILMIC. I am here on behalf of the Office of Lawyer Regulation. OLR is very interested in providing education on the new trust account rule and related rules whenever it has an opportunity, and this was an absolutely spectacular opportunity. We're reaching a lot of people today, and I am very glad to be here. The trust account rule has recently expanded lawyers' capabilities as far as electronic banking. In doing so, it has also increased lawyers' risks in doing electronic banking. The opportunity and the risk run hand in hand. We'll start out looking briefly at the rule changes and the court's specific statement in why it took this step at this particular time. Going back even to 2004, when the court recreated the rule for the last time it did this complete overhaul, it wanted OLR to keep abreast of changes in electronic banking and to bring back to the court at the appropriate time a new rule that would enable lawyers to begin utilizing electronic banking as much as possible and as safely as possible. And to that end, a committee was established in 2012 that worked for 4 years on studying this process. We got a lot of input from the Wisconsin ACH Association in addition to the Bankers Association of Wisconsin. The Wisconsin ACH Association is involved strictly in the electronic transaction of business. It is an organization that is in the state of Wisconsin, but it also has a national association called NACHA. So there are people who have much more complex rules even than the lawyers in the state of Wisconsin do, and WACHA manages to keep up with federal regulations on banking. The court's purpose in doing this was to meet the demands of business, to meet the demands of clients, and everyone who is interested in basically practicing law in the 21st century. There have been such significant modifications to the way that banking is done. At this point, only one Federal Reserve location handles checks. It used to be that every Federal Reserve around the country did so, but the volume of checks has so decreased that only one center is necessary at this point to manage that responsibility. That, above just about anything, reflects the volume and the increase in electronic banking. A new term that appears in the trust account rule is commercially reasonable security. This is a term that bankers are pretty familiar with. It's not necessarily a term that lawyers are familiar with, and don't let it scare you. This is something that is important, that is going to be necessary as you embark or continue to utilize electronic banking in your business practice. You will need to be aware of what particular products are necessary and what steps you as a lawyer and your staff need to take to protect trust accounts and business accounts as well. Business accounts and trust accounts are connected, obviously. And we'll talk a little bit later about what some of the commercially reasonable security measures are that you should be familiar with, and that certainly when you're looking into doing electronic banking, you should discuss with your financial institution. For the first time, lawyers can engage in remote deposits of funds. Under the former rule that was in effect up until July 1st, remote deposits are internet deposits, and they were prohibited because of that. Now they are permitted. Remote deposits may open your system to some additional challenges that you didn't have in the past. One of the things that you are likely to hear from your financial institution is that when you remotely deposit a check, you will have to destroy the original check in short order. There will typically be a timing requirement established by an agreement with your bank. Don't be alarmed about that. It is a security feature. It is designed to avoid check fraud, to prevent theft of account numbers and redeposit of the same item more than once. Another thing that your bank may ask you to do is to manually endorse checks that are deposited remotely. Many of the software programs that remote deposits can be accomplished through will automatically insert an endorsement called an electronic endorsement. That is not adequate security for your electronic deposits. Please be aware that you should manually endorse in addition to electronically endorsing, or as an alternative to electronically endorsing your checks. And by using manual endorsements, in particular, one area that I have seen over the last 10 years where endorsements have been critical is the practice of personal injury law. The personal injury practitioner typically gets a check. In the past, it was payable typically to a client and to the lawyer, or occasionally to a third party who was subrogated in the particular matter. Today, many of the checks are payable simply to the lawyer's trust account. Now, that difference means that the burden is on the lawyer to make certain that the endorsement is adequate. We've found that even stamped endorsements may not ultimately be safe and effective. You would need to assure that you endorse it to your trust account and put your signature on it. That way you can likely avoid the check coming back as improperly endorsed. And it's only in personal injury cases that we've seen overdrafts relating to endorsement issues. So I find that kind of interesting, but it is a warning out there to be very careful when you're handling a personal injury settlement, that you properly endorse the deposit item. Commercially reasonable security also applies to deposits via credit card, prepaid cards. All kinds of cards are now permitted, and the types of cards are likely to expand. Do we have a question in the back?
We do, Mary. A web question. The viewer writes, for a personal injury law firm, instead of cutting a check from my trust account to my business account for my attorney fees and costs, am I permitted to do it by electronic transfer from my trust account to business account? Either way, I would keep an accounting book detailing all such transfers. Assume also a traditional IOLTA and business account.
Okay, if it's a traditional IOLTA, you cannot make an electronic transfer from that account. You would still have to utilize a check to make the transfer. Now, on the other hand, if I assume, unlike the caller or the writer asked, whether or not it could be made from an e-banking trust account or what I'll later describe as an all-in-one trust account, those two types of accounts allow for electronic transfers, but the traditional IOLTA, the standalone IOLTA, does not permit electronic transfers between that account and the business account. Okay. Electronic deposits and disbursements are also permitted, and as I mentioned, those are limited to the e-banking type accounts that are now available. Okay, one thing to be aware of when you are accepting deposits from a third party, and this could be any type of electronic deposit, you cannot accept it if the third party could withdraw those funds without your authorization. That is still a prohibited transaction. In addition, third-party withdrawals are prohibited. What this means is that you can push funds electronically from your account, but you cannot authorize someone to go into your account and pull funds out of it. So there's a distinction there. Think push is good, pull is bad. Don't allow someone to go into your account because then you lose control of that account. And we have at OLR a lot of experience with lawyers who have allowed third parties to go into a credit card trust account. And it is particularly, or was, a problem in the collection law practice, where agents of the client were allowed to go and pull funds out. Well, in the collection area, there are a lot of bounced checks, as you might imagine, and the agent was not interested in putting funds back into the account when the debtor's check bounced. Consequently, we had rolling overdrafts on these accounts. The message here is that by allowing someone to go in, the lawyer loses control of the funds in that account, and that is something that you cannot do. Now, I mentioned earlier we're going to talk about the reasonable security measures that are available. And bear in mind that more than one of these measures may be appropriate to your law practice. In addition, these measures that we have today are likely to be superseded as the scam artists get smarter. There are likely to be changes to the products that are available to prevent them from being successful. First of all, and this is something that WACHA, the ACH Association, which is most familiar with electronic banking and its risks, their number one recommendation is that lawyers establish a dedicated computer that is not networked or connected to the other computers within the office, and that computer be equipped with hardware and software to prevent viruses, Trojans, malware attacks. So you need to have that type of protection on that segregated computer and utilize that only for your banking purposes. Secondly, and as this was mentioned earlier, education of the lawyers and staff in your firm is critical. There is no better way to avoid problems with attacks and phishing schemes than to have staff who are available of the pitfalls that are out there. Lawyers and staff need to be educated on things like corporate account takeover, social engineering techniques, and those were talked about earlier this morning, and other cyber threats that are out there. ACH debit blocks and ACH positive pay. These are two types of protection that are available for banking accounts and will prevent funds from being pulled out without the lawyer's authorization, or will prevent funds from being taken without verification by the bank that it was an authorized transfer. Those two types of protections should be discussed with your financial institution to determine, based upon the types of transactions that you want to conduct, whether those tools would be helpful to have in your tool chest. Online review of the account activity, at least daily, is another critical factor and something that must be done. Someone in your office needs to check your bank account at least on a daily basis. The reason this is so critical, the daily basis, is that if there is a fraudulent ACH transaction that occurs in your bank account, say funds are pulled out electronically and you're not aware of it by some scam artist, you have 24 hours to notify your financial institution of that suspicious activity. You are not subject to the protections that consumers are. They will have up to 2 months, I believe, 2 or 3 months to report such activity. But as a business, you have 24 hours. That makes it absolutely critical to do that checking on a daily basis. Security tokens have already been mentioned, so I'm not going to go into detail about those, but again, we're talking two-factor authentication is a good thing. Dual controls. This is something that can also be established to prevent funds from being transferred inappropriately or without proper authorization, and that involves 2 people in an office each authorizing a transfer of funds. And that is something, again, to discuss with your financial institution based upon the types of transactions that you're utilizing in the conduct of your business. Another and the final aspect here to consider is to have a contingency plan in place before an emergency occurs, before you discover that there's been a fraudulent ACH transfer of $10,000 from your trust account. You need to have a plan in place that will allow you to contact a real person, not the bank's main line where you're going to go through a telephone tree for 3 or 5 minutes. So communicate with your banker. Find out who is going to be my backup if there is a problem. What number do I call? Who do I talk to? If that person isn't available, who's the backup person at the bank? You need to act swiftly because electronic banking moves swiftly. ACH transactions are even getting faster. The Federal Reserve is implementing what's called same-day ACH, and that means funds are available within the same day that a transfer is made. And this involves additional costs to the person requesting a same-day transaction. But the bottom line is transactions keep moving faster and faster and faster. And while that's a good thing in some respects, it is an additional risk factor when you are dealing with other people's money. And you need to exercise extreme caution and probably use the dual authentication when you get an email from your client saying, I would like the money transferred here rather than where I originally directed. Do not rely on an email communication to change the direction of a transaction. Verify with your client to safeguard those funds. That is one mechanism that lawyers have been the target of, to have funds transferred to the scam artist rather than where their client has directed. We have, under the new rule, what I'm calling new and newly expanded options. Remote deposits, we've already mentioned. They can now be conducted not only in the electronic banking accounts, but also in the traditional IOLTA account. So that is the one type of electronic transaction that is permitted in a traditional account. You will need likely hardware and software, work with your bank on that, discuss whether or not it is secure to do it via any method, whether the bank would recommend or strongly oppose doing it by cell phone or rather smartphone. You need to have these serious discussions about security in connection with remote deposits, because you could be placing your client's funds at risk if you are not appropriately securing the accounts. Consult your financial institution on the hardware and software requirements for conducting remote deposits. Also, what are the law firm's responsibilities going to be in this process? And those I discussed earlier. They involved destroying the original checks and the endorsement issues. Safeguarding the deposit of checks is something that will likely involve shredding on site as opposed to sending them off to be shredded elsewhere. So bear in mind that you should have some equipment in place to properly cross-shred any deposited checks that are the originals, and they need to be kept securely until that date that the bank will tell you you can dispose of them. It would typically be somewhere between 2 weeks and a month that the checks could be shredded. This is an example of the restrictive endorsement that is one of the safest ways to make a remote deposit, or any deposit for that matter. You'll see that it includes the law firm's stamp for the trust account and the personal endorsement of the lawyer as well. Moving on to the destruction of deposit items, I've already mentioned this, but this screen points out the purpose and why you need to do it. Just bear in mind that cross-shredding is the safest way to shred and destroy checks and make them unusable. Deposits via debit, credit, prepaid, and other payments. Card payments to lawyers are expanding. They're expanding to all businesses, not just lawyers and doctors. Everyone is using cards to pay. This has been permitted in credit card trust accounts since 2007, but as of July 1st of this year, the credit card trust account is extinct. It has been replaced by an e-banking trust account. If possible, the safest thing to do in connection with credit card payments is to arrange for your fees and surcharges on those transactions to be deducted from a business account rather than your trust account. It gets very complicated doing the record keeping when you're dealing with deposits of less than the amount that was paid by the client. So if all of this is handled via your business account, you will get intact into the trust account the full amount of a credit card payment, and you will deal separately and securely with the fees and surcharges in your business account. If you find that your bank will not agree to that, I would suggest doing a little more research and seeing if you can find a financial institution that is willing to do that, or a card processor that is willing to accommodate you in that way. And there are processors out there that will do it depending upon the law firm, the volume of business. There is even a particular program that the state bar has available that is particularly targeted at lawyers. That too should be investigated. Excuse me. One thing to bear in mind in connection with your trust account is that the new rule imposes specific responsibilities for security. This is in connection with the fact that the use of electronic banking is expanding, and it is expanding at a very fast rate. So the rule, taking that into account, and the court recognizing that, has created a rule that points out to lawyers that you are required for the security of each transaction in your account, and you need to have commercially reasonable security in place for that account. Each disbursement must be authorized by a lawyer and paid to the appropriate party. Signatory and transfer authority is another issue. Right now, signatory and transfer authority needs to be either by the lawyer directly or by someone to whom the lawyer has delegated that responsibility in the law firm, and for whom the lawyer has oversight responsibilities. So the court's goal here, and OLR's goal in providing this information, is to be sure that lawyers recognize that they are ultimately responsible for the activity in their trust account, and assuring that they have procedures in place and an educated staff that is capable of handling these responsibilities as well. One thing to bear in mind is that education on cybersecurity today is great, but it does not end today. It is something that is going to be needed potentially on an annual basis, and based on cyber threats and other things that are going on in the news, you may need to update even more frequently than an annual basis. This particular screen attempts to point out that there has been some confusion in the past about ACH and wire transfers. There are distinctions. There are differences between how these transactions are handled, and we want to be sure that you don't mistake an ACH, or what's called an electronic funds transfer that's conducted from your law office, with a wire transfer. Now, ACH transfers can be conducted from the law office. They are handled through the automated clearinghouse or through one of the Federal Reserves around the country. Basically, the money moves from your account to a client's account or a third party's account based on your pushing the funds out, and you do that from your system. It's typically reversible, and it is permitted in trust accounts that have electronic banking capabilities. And those two types of trust accounts are called the e-banking trust account and the alternative to the e-banking trust account, which I refer to as the all-in-one because it is shorter than the alternative to the e-banking trust account, and it makes a little more sense from a user standpoint as to what the difference is. The wire transfer, on the other hand, is something that you need to request your bank to perform. It is conducted between two financial institutions. The cost is substantially higher than conducting an ACH transfer because you're bringing the banks into the transaction and they are securely performing it. A wire transfer is significant because it is not reversible via chargeback. It is permitted in any trust account, not just the electronic banking accounts. Wire transfers have been permitted going back probably at least the last decade or two. So that's nothing new. However, don't confuse wire transfer with ACH or EFT. There's a lot of acronyms, and when I started attending banking conferences, I was blown away by all of the acronyms that slip out of the mouths of banking people. So you'll become familiar over time with those types of transactions that you plan to utilize with your firm. But ACH means an automated clearinghouse transaction. EFT, electronic fund transfer, those are synonymous. However, ACH and wire are not. As of July 1, you can conduct ACH transactions in the e-banking trust account and the all-in-one account. The all-in-one, and I will get into this in a little bit, is a single account system. The e-banking trust account is a dual account system that is modeled after the credit card trust account system, which required a credit card trust account and a traditional trust account in order to work. In addition, ACHs are permitted in fiduciary accounts. How many of you are familiar with fiduciary accounts? Okay, I will just clarify that briefly. A fiduciary account is defined in the trust account rule as an account in which the lawyer is serving a particular role other than serving strictly as an attorney. For example, the lawyer is a personal representative of an estate, or the lawyer is an agent or a guardian and is maintaining funds in that particular role. The accounts that lawyers maintain in those capacities are called fiduciary accounts under the trust account rule. The term fiduciary applies to a lawyer, however, with respect to each and every situation in which a lawyer holds funds for a client or third party. ACHs, as I indicated, are not permitted in the traditional trust account. So be very cautious about identifying the proper account type when you set up an account and you're planning to do electronic banking. If you're going to utilize the traditional account, you are not going to be able to perform ACH transactions. Okay, what do you talk to your bank about when you are establishing an e-banking account or an alternative, the all-in-one account? You need to discuss what the fees and what the bank's requirements are going to be for online services. You need to talk about what the lawyer's responsibilities, your law firm's responsibilities are going to be in this process. It's not necessarily all on the bank's shoulders, in other words. The electronic banking world is going to impose upon lawyers and law firms additional burdens that the standard banking practices conducted in a traditional trust account did not. So beware that you will be asked to take additional steps to assure that you and the bank as a team can keep your account safe and secure. The firm also has to have an ability to record certain information in connection with each transaction. Now, this is interesting because the court removed other record-keeping requirements from the trust account rule itself and made them guidelines that OLR posts on its website. So the requirements to keep a transaction register and client ledgers are now guidelines rather than rules to be violated if you don't keep those records. That's not to say you shouldn't keep them, but with respect to electronic banking, the court has added rather than detracted from the record keeping. It identifies specific information that you will need to put into the bank's online system every time you move funds. The ACH record-keeping responsibilities that are specifically outlined are some basic information that every transaction requires, and that is the date, amount, and payee. Any transaction conducted online or by check has to include that information. However, the additional information that lawyers need to keep is the client matter and reason for disbursement. And you will typically find that there is going to be a limitation on the number of characters you can type in to this transaction to identify that information. So check with your bank on how much space you will have to identify a client and a reason for the disbursement. It could be simply client John Doe, legal fees and costs. It could be payment to your client, client settlement, first installment, if it's an installment payment. You need to determine how best to identify the client and reason for disbursement in a short segment that you will be given to input that information on your bank system. And that will be retained by the bank as a record relating to that transaction. Now I'm going to just go through a little bit about e-banking trust accounts and the alternative to e-banking trust accounts. An e-banking trust account is going to enable a lawyer to accept funds in trust via various electronic mechanisms. Lawyers have frequently, over the last few years, been required to accept electronic payments from the federal government. There have been no alternatives provided by the federal government for transmitting certain types of payments like tax refunds. And so this new rule equips lawyers with the capacity to conduct those types of transactions while at the same time not violating a rule that prohibits electronic transactions other than fees and costs. It will prevent funds from being withdrawn via surcharges and chargebacks, particularly if you get your bank to cooperate with the deductions being taken from your business account rather than your trust account. And the last and probably the most significant purpose of the record-keeping requirements is to be sure that you properly identify information that will enable funds to be tracked and ownership of funds to be retained clear in the event that there is an issue with your personal record systems going down or lost. You'll have a backup with the bank's system. Now, the mechanics of e-banking are outlined on this particular slide, and it goes on for a bit. So I'm just going to touch base on a couple points that distinguish the e-banking account from the all-in-one account. The first is that the e-banking account does require a secondary account, what we're calling the primary IOLTA. The primary IOLTA is going to be your traditional IOLTA account. The only types of electronic transactions permitted in that primary IOLTA are to move funds from that account back to the e-banking account or to move funds from the e-banking account to the more secure primary IOLTA. The concept here is that by having a pass-through account, you are able to better secure the funds that you are holding in trust, which potentially could be a significant amount of money, and reduce the access to that money via the electronic transfer systems. The security requirements for that account are commercially reasonable security. And again, those are the topics that we went through earlier. So recognize you need to talk to your bank about that. You can conduct various types of electronic transactions. The only prohibitions in receipts and disbursements of funds are those that take control of the account out of the lawyer's hands. Remember, you can push, but don't allow someone else to pull. There are surcharges and reversals involved anytime you're taking credit card or debit card transactions. And those are situations that you also need to plan for how they will be covered. And again, the best option is have the business account the source of pulling of those fees and surcharges. If not, you will need to retain business funds in the account to cover those fees and surcharges. Transfers in the e-banking account are broken down into the nature of the transaction you're conducting. Because you can transfer any types of funds now that are deposited, there are specific requirements for advance fees, where they get moved and where they need to sit. And that is going to depend on whether you're using the alternative to holding unearned fees in trust. You can put fees into your trust account and hold them until earned, in which case you would transfer them either electronically or by check from the e-banking trust account to your primary trust account. On the other hand, if you are claiming and utilizing the alternative to holding funds in trust, and you have an agreement with your client to do that, the client makes a payment to you that consists of fees and costs. That is deposited into the e-banking account. You move the fee portion by potentially electronic transaction to your business account and move the cost portion to your trust account. Costs cannot be placed into the business account. There is no alternative to holding cost advances in trust. I'm not going to go through the other types of transactions, but this information is available to you on this screen and also on OLR's website. There are permitted disbursements and prohibited disbursements. There are record-keeping requirements for electronic transfers, as I discussed earlier, with regard to what you put into the online banking system. What to do about shortfalls and negative balances is also something that needs to be considered. And the rule requires you to replace funds that are deducted from the account within 3 business days of those deductions. So this again requires you to have pretty close contact with your account activity. And if you are reviewing that activity, as you should be on a daily basis, you will catch this. The alternative to the e-banking trust account is the all-in-one. And this particular methodology utilizes only one account, and you conduct all transactions within that one account. Interestingly enough, you need certain additional security features to conduct or to utilize this all-in-one account. The biggest difference between the all-in-one and the standard e-banking, of course, is the distinction between, do I want 2 trust accounts or 1 trust account that I do all of my checking and all of my electronic banking? Because that imposes additional risks, that type of account requires additional protections. And the additional protections will be twofold. You are going to be required to have reasonable security. You are going to be required to have, if at all possible, funds deducted from your business account rather than the trust account. The account requirements here, again, would be an IOLTA, and a business account is also a typical feature of any law firm that maintains funds in trust. The firm is required to also have a business account in place. The reasonable security, again, is used for this account. You need to discuss with your financial institution which of the currently available security features are going to work best for you, and that's going to be based on the types of transactions you're planning to conduct. Prohibited transactions are typically, again, going to focus on the push rather than pull transactions. You cannot conduct a transaction that is going to allow a third party to go into your account and pull funds out. Record keeping is something that right now, in connection with the all-in-one account, is in the process of being changed. We are anticipating that the court is going to issue a corrective order that is going to include putting the information into your all-in-one account that is currently required only in the e-banking account. This was perceived as an oversight in the drafting of the rule. So in the near future, I would anticipate that you'll see the same record-keeping requirements for the all-in-one account that currently exist only in the e-banking account. The other big distinction between the e-banking account and the all-in-one is the requirement for a bond or crime insurance, and that is specifically required by rule. The all-in-one account requires lawyers to keep either a bond or a crime policy in an amount that is sufficient to cover the maximum daily amount that was held the prior calendar year. The purpose of this is to assure that if funds are stolen from the trust account, regardless of whether it is a staff member of the law firm or a hacker that accesses the funds and pulls them out, the loss is protected by insurance coverage. Now, this is something that you would need to contact an insurer about and determine what type of coverage you need. Typically, you're going to want to look at crime coverage, and that would cover employees as well as cybercrime. We're not looking, and this rule is not focused on protecting information. That's a different rule in a different area entirely. You do have responsibilities for security of information, but the focus of the trust account rule and its crime insurance requirement is to actually protect funds and assure that clients do not lose money that is held in your trust account through security breaches. At this point, then, we're pretty close to quitting time, and are there any questions? Okay, seeing none, I think we can wrap up this segment. Thank you so much.
Thank you, Mary. 10-minute break, and we'll come back with our third and final hour. All right, back for hour 3. I just want to remind all of you here that are in person, you should have an evaluation form in your materials. Please fill that out and drop it off at the front desk on the way out. We use your comments and your feedback to help produce other programs in the future. For those of you on the web, you will be getting an email with those same evaluation questions. All right, hour number 3. Pat Mckenna is with us. Pat is president of Mojo Web Productions. It's a Milwaukee-based web development and web design and digital strategy boutique focused on law firm, small business, and nonprofit website development. In prior lives, he was webmaster right here at the State Bar and director of Internet Services for the Daily Reporter and the Wisconsin Law Journal. Please help me welcome Pat Mckenna.
Thank you. Can you hear me okay? Everybody got me there? All right, great. Are you scared? Did these two guys make you scared about all the security issues and everything? Well, let's switch gears a little bit and make you smile and get you thinking about the web and how to market your firm for the digital age. The numbers aren't really all that fantastic. More than 35% of legal consumers start their search for an attorney using online resources, yet only or 40% of small law firms don't even have websites. And outside of like major players, the Foley and Lardners, Quarles and Brady's, places like that, the sites that are there are archaic and unready to meet the demands of today's digital consumer. 35% of law firm website designs have been updated in the last 3 years. The rest continue to suffer under these designs that go back to 2006, 2005. I met with a client the other day, hadn't updated his website since 2004, believe it or not. I'm going to get that changed real fast. And most importantly, only 1/3 of law firm websites are optimized for mobile devices. You might not think that it's important for a law firm to be optimized for the mobile market because the decision for a lawyer is more deliberate, requiring some comparison and time with materials on a website to make an educated decision. You actually give the consumer more credit than they deserve. They are looking at their phones for everything, and websites have to be ready to meet that kind of consumer browsing. So how do you solve it? Well, I was sitting around one night, and I was watching The Sting with Paul Newman, one of my favorite movies, and I was thinking about this. I was thinking about this presentation in particular, and as I was going through the movie, if you recall, each episode in the movie was set up with these beautiful pieces of art: the setup, the tail, the wire, and the hook. I started thinking to myself, if I was a small business, or if I was a small law firm or a solo practitioner, I would be looking to pull a sting against large law firms and medium-sized law firms who have more resources, more attorneys, and more money to find consultants like me to, do the important work that goes into marketing a website. So I started thinking, the Sting has all of the elements to show these people, how it's done. So without further ado, the setup. The first thing to know is that the majority of law firm websites, as I mentioned, are terribly archaic, and those that do have modern designs, even those that are optimized for mobile, are still offering mere brochureware. I've remarked over the years since I left the bar that I could design law firm websites in my sleep about attorneys, practice areas, resources, contact done, you know? And that's not enough to differentiate yourself from your competitors. So solving for the shutout is really of the utmost priority. The way to solve for it is to modernize your website by moving it over to a program called Wordpress, which is an open source free content management software that's offered for free with most web hosting plans. If you are with a provider such as Bluehost, 1&1, HostGator, and many others, they offer one-click installation of WordPress. And the great benefit to using it is that you join over 25% of the world's websites that rely upon it for the daily management of their websites, including Fortune, Time, the Washington Post, ESPN, the Wall Street Journal Law Blog, and more. And the reason why they're relying upon it is because it offers browser-based, what you see is what you get editing. If you can navigate through an online form, which we've all done for various purposes, you can pull off a beautiful website by just filling in the blanks, as we'll see in a minute. You don't have to know anything about HTML. The language of the web. You will never see any code at all as you create your content. That what you see is what you get editing console, which I show on the next screen, also features very, very intuitive Microsoft Word icons. And because so many people rely upon Word for writing correspondence, doing reports, filings, etc., WordPress is set up to take a Word document and all of its coding, bold, italics, indents, etc., and you can copy and paste it into WordPress, and it will inherit all of those special layout instructions. So bold will become bold in HTML, indent will become indented in HTML, and you or your staff don't even have to think about doing anything beyond copying and pasting into the program. The greatest thing for solos, and you guys are in the same situation as the startups that I deal with and small businesses, in that every dime counts. And if you can get away with a DIY solution, so be it. And WordPress offers that. By using this program, it's paired with a design library that offers thousands of templates that you can use to design your website. And they're all installed with literally 1 or 2 clicks through your browser. And in addition, what makes the platform really shine is the fact that you can add thousands of software plugins to do things on your website that only years ago you would have paid hundreds, if not thousands of dollars to put on your site. If you want quote forms, if you want fully functioning discussion areas, knowledge bases, there are plugins for that. And they're like the templates, easily installed with just a simple click. This is what the Wysiwyg page editor looks like. You put in a page title, write your copy, choose a template over to the right-hand side, and then hit that blue Publish button, and you're done. The template and the program does all of the work for you, and you don't have to worry about calling up your IT guy or finding the best and the brightest IT people in your office. This is literally something anyone can do who's filled out a form online. And these are the kinds of templates that you can go with. Even though WordPress offers thousands of free templates, sometimes it pays to go out into the commercial market as well to see what templates are available out there. And as you can see, this is a $75 template for WordPress. This is a whole website. All of the pages and front cover and functionalities from sliders to testimonial fade in and fade outs come with these template packs. And $75, and if you are a real nervous person with IT or want to offload the installation of these templates to the good folks at Template Monster, you can pay a few more bucks, and for $124, they'll install the template for you. But as you'll see once you get into the program, paying that extra money really isn't required, because installing a template is easy as uploading one file that they provide to you, and they provide you with instructions to install it. So, you know, WordPress really caters to the common man, if you will, the common business person who is not looking to become an HTML programmer or a web designer. They're looking to run their business and do it efficiently and quite quickly. So, even with good template packs, and there are many out there that fit the law quite nicely, that's only a starting point. You know, I tell my clients to, you know, think of design as merely the house that you're going to be moving into. You wouldn't live in a house without furniture, without knives and forks and beds and everything else, and your website is no different. In terms of how your site is structured, you really need to keep in mind a few things. The first thing is, all of us, when we go out online, whether we're going to Facebook, whether we're going to Google to do a search, have informational expectations. And we expect the websites that we go to, either through search or directly, to meet those expectations with information. But, as we saw on a previous screen, if you don't have a website that recognizes that and gets information in front of your prospects and potential clients, you're going to be left by the side of the road. They'll move somewhere else where they can get an answer quite quickly. That's why you see in certain industries, you know, law is a good example, sites are structured pretty consistently. That's because in an age of tabbed browsing, where I can put 5 tabs in my browser and look across 5 different law firms, I can hop quite quickly to the areas that I want to look at. So you see about our firm, attorneys, practice areas, because the other guy is doing the same thing. If your site isn't structured in that manner, you're putting yourself at a disadvantage. On that point, those points of navigation that you see along a top bar, along a sidebar, should be intuitive. They shouldn't be hiding information. They should be direct. Practice areas should provide only that information. Detailed discussions of what your firm practices. In your attorney's area, that's all that should be there, are attorney profiles and nothing else. You don't put attorney news or attorney blog posts. That's for another area. And on that point, you know, that speaks to the fact that sites that succeed are well organized, well structured to handle the information that's on board, as well as these informational expectations. Interestingly, though, as we see at the bottom here, only 53% of law firm websites have organized site content, meaning that it's all over the place. You know, oh, where are we going to put that? Oh, just throw it in the about area. It's like, I've heard that more times than I care to remember. So keep in mind that what you would expect from a website, you know, is likely what your potential client expects from a website as well. And in terms of the window dressing, in an age of royalty-free photography everywhere, campy, canned images of people shaking hands, of, you know, conversations in a business setting are becoming quite cliche, and end users go so far as to make jokes about them on Facebook, turn them into memes, you know, another corporate website with great original photography, hee hee. If you can afford to do original photography of the interior of your firm, certainly of your attorneys, it's a good investment to do so. And always keep in mind that your contact information might be a no-brainer, but it's forgotten on a lot of sites. It should always be present. Your phone number should always be in the footer of your page, and the reason why is because that information is sucked up in search. It's going to come up naturally in the search results, and it's a quick way for people to grab their smartphone, hit that number, and go over to make a phone call to your site. And don't get overwhelmed by cool gadgetries and technologies that are out there. I'm sure that we've all been to websites where the first page is like a pinball machine. And we're just looking for the contact information, or we're looking to browse some information, you know, specifically, and we've got this sliding screen, and oh, it looks so cool. That's you being impressed and not thinking of, you know, the potential client coming in. And it becomes a real issue when you're comparing websites. It's like, I've actually seen studies where 5 sites are preloaded into a browser for testing of users and what they gravitate to in terms of good designs. And they close tabs with all that gadgetry going on because it's getting in the way of them finding what they need or completing a task. If you want to know more on that point, take a look at this article, 17 Things People Absolutely Hate About Your Website. And obtrusive technology is one of the ones that tops the list, as well as plenty of others. The tail. Your story, your people, what you practice is the tail. And content is everything on the web, especially these days. We're seeing a real content renaissance. Because of WordPress, because of other templated content management softwares, everybody's got a pretty decent website these days. And that's great and everything, but where the rubber meets the road is what you can offer me in terms of written materials, video, social media, etc. So when you think about your sites, turn off your browser and think about how you want to communicate your identity to your existing clients and to your potential clients. Doing content well has the advantage of demonstrating your expertise and leveraging your expertise in other environments that matter, such as social media, which we'll get to in a minute. It also creates a meaningful connection with your audience. Brochureware sites are easily spotted and speak in such generic terms that they don't create connections with us. And that's not only in the law, that's in other industries as well. I want to know about your firm, but I also want to know what makes your firm unique, and I want to be told that in a genuine and meaningful manner, not in a salesy manner. It's my expectation that you're going to put some effort into it. Content also underscores the value of your firm over others. Those firms that do take a brochure approach to the development of their websites will stick out like sore thumbs, and your unique presentations will register with them just because they stand out as different alongside of your competitors. Good content as well also increases search engine optimization. Before you write a check to a smiling SEO consultant for thousands of dollars, I would suggest that you reflect on the fact that what's being searched Anybody? Content. So if you don't have content on your website, there's nothing magical that an SEO consultant can do to rocket you up in the listings. In fact, they're going to charge you even more to create content that does get you indexed by Google and Bing and other engines. Content also enriches and extends the reach of your marketing, because if you do content well, especially blog content, which we'll get to in a minute, you have the ability to repurpose that content for use in social media, for use in email newsletters, and a variety of other marketing tools. And as I said, it sets the stage for social media strategy, which we'll treat separately in a moment. Yet, despite all of that, lawyers really aren't much for blogging. In fact, if you go to law firm websites, even large multinational firms, you'll find that content is pretty lean on the ground. Only 8% of lawyers maintain a legal blog for professional purposes, where they discuss issues that are important to their clients, development in the law, etc. And only 24% of law firms have a blog, which is up from 22% in 2012, but that's not really impressive, you know. That's like saying, you know, it's like I was in 5th and now I'm in 4th. Give me a trophy. And that's from the ABA's Legal Technology Survey in 2015, so it's fairly current. So what is a blog? We hear about blogging. We hear about blogging all the time, and without getting into the history of blogging or the technology behind it, a blog is nothing more than a web-based program that's used to chronologically add or organize content on your website. It is like writing an article, and the article is placed in chronological order in an index. That's blogging. And it can take many, many forms. You can focus on one subject, topic, or many, all of which are categorized and archived. Say you write an article about changes to the tax code that deals with intellectual property issues. You could have a category for tax analysis. You could also have a category. You could also have a category for intellectual property, and that article would appear in both. And you can have as many categories as you want. I have one of my main clients is a family law attorney who writes. He's a prolific writer, and he has, I think we're up to about 40 different categories right now. And many of his articles will fall into 10 different categories. And the reason why they're categorized is so they can cover those informational expectations that his end users have. It's like, oh, he wrote a story about custody issues. I'll go under divorce, or I'll go under custody. I'll go under settlements. And you give people multiple options for seeing that piece of content because of that categorization. And blogs can be open or closed for comments. The trend is to close comments on websites and leverage social media to keep them open. Or to offer the ability to comment. And given the issues that we've heard this morning, especially by Art Safran in the first presentation, I generally tend away from keeping comments open on websites because it does introduce security issues, because somebody has to sign up for an account. Which gives them access into your system. And even though there are plenty of security, really, really good security softwares that work with WordPress, why give them a door if you don't have to? And generally, small websites don't get comments. People just aren't going to take the time to set up an account to comment on what you've written. You know, that's why social media becomes a nice solution to that. They're ready to comment in that environment, and they're already logged in. And again, your content in a blog can be very, very flexible. It can be written, it can be links to articles and sites, it can be curated news articles that you've read that your audience might be interested in. It could be audios, could be videos, anything. The one thing to kind of chase from your mind, I tell this to my clients all the time, is don't think just about the written word. It's not just about writing, even in the law. It could be, I've done blog posts that are a single introductory sentence for a video embed that wasn't done by the client at all. It was taken from YouTube and was done in another market and speaks to the issue that for their industry for their site. So you can do all kinds of things with a blog. And creating great blog content is pretty easy because there's content everywhere. And most of it is available for free or with a little bit of sweat equity to curate it and bring it together. You could share a comment on industry or legal news. You could comment on court decisions and upcoming legislation. You could do, as I said before, video embeds, public policy analysis if your practice focuses on business issues especially. You could have, if you are part of a practice, a firm founder column is always easy to pull off, just a monthly reflection on issues going on. Top 10 lists. The reason we see so many top 10 lists, top 5, top 3, top 8, is because lists are easy to create, and most of them are subjective. My top 10 is different from your top 10. But that doesn't make my top 10 worthless. Might be just as good or better. But it comes up in the end user's mind as, okay, cool, top 10 things that I need to know about my divorce. Top 10 things that I need to know about incorporating my business over setting up an LLC. These are things that register in the minds of the end user and again meet their informational expectations. Client testimonials, you can actually invite your clients with a simple email to tell their story about working with your firm. People love that kind of stuff because it's on the ground. They can identify with that person because they are that person. What's it like to work with this firm? I just don't get a quote. I get a full experience, and a good client, might put that together for you. I like problems and solution blog posts, especially for technical things, and that kind of approach, can also be used in identifying what the problems or challenges of your potential clients are, and providing general answers that lead to a higher interaction, whether it's submitting, a contact form, giving you a call, sending you an email. Charitable event coverage and photo galleries. This is intentionally low on the list because this is what a lot of firms do in social media. They'll do what I like to call the social media cheat, which is putting charitable event information out there almost as if it's a press release. And we've done social media. Here we are at this Komen Walk. Here we are, working at this homeless shelter, and we've got 4 or 5 pictures in a gallery, and boom, we've created content. Yeah, you have and you haven't. You've just found opportunistically something that you can put on your blog, but it is something you can put out there. And peripheral subject information, and by peripheral subject information, I mean it's not necessarily related to your practice, isn't necessarily something that your firm might provide, but it stands on the periphery of an issue. It's like, I use family law again. there are lots of peripheral issues in divorce, you know, from parenting issues to financial issues. And even though you might not provide services or representation that speaks to those things, you can still put that in front of your potential user to save them a step, which again in the marketing mix makes you a lot more desirable than another person who just said, yeah, I practice family law and child custody, I deal with child custody issues, boom, the end. You've actually, yeah, I practice all that stuff, and if you go to my blog, I have a whole area where I gather together resources that would be of interest to people who are about to go into a divorce as a single person, without children, or families as well. You know, here are these types of resources. And all of those things have one thing in common, which they are valuable to potential and existing clients. And if you blog regularly, it does generate results. If you blog 20 times a month, which would be 4 blog posts a week, which is at the higher end of blogging, you're going to get 5 times more traffic to your website on average. The reason being is that you have more content for Google to suck up. And more entry points for people to come into your site. And most importantly on this screen is here, companies with 51 blog articles experience a 77% lift in median monthly leads because they have more traffic. If you want to know the secret to search engine optimization, it's not keywords. It's entry points, backdoor entry points. The end user is typing a sentence or typing a few keywords into their Google search engine, and what comes up are things that match, you know, semantically what they have there, and that might be a blog post on your site that comes up. You're not looking to send them through the front door necessarily. You're looking to get them into your website. So if they come in through a back door, so be it. Once you've got them in your domain, you can move them around and they can begin to explore. So the more you write, the more you put blog content out there of any form, the better your chances are of having those natural opportunities. But you have to be organized. And I come from a journalism background. I was one of the I was an inaugural team member of JS Online way back in 1995, and this is kind of secondhand to somebody who's been a reporter like I was in terms of having an editorial calendar and knowing what I'm going to be writing about from day to day, week to week. And I offer these free templates on my website for my students and clients to do just that. So you can sit back and you can think, what am I going to write about this month? How many things am I going to write about? And you're away from the computer doing this, you know, or you might be using the computer at some point to gather up resources, but you're planning and getting an idea well in advance, so you're not writing on the fly or doing shotgun articles that really don't have a lot of value. You just want to get something done. This allows you to do it, you know, with reflection and with goals in mind. So feel free to download those. I have them available in PDF and Word format. So you can take advantage. You can take advantage of the Word templates and be able to type instead of printing out a PDF and writing in. But a lot of people like to do that too. 39% of lawyers have obtained clients from blogging, which is kind of strange. Seeing the low number of firms that actually maintain blogs, and the amount of time, which is obviously critical to attorneys because of billable hours, isn't all that egregious. And it becomes very, very manageable if you're using those publishing calendars. 2.1 hours a week on average by attorneys who were surveyed by the ABA to do simple blogging. It's not a lot. And if you have content prepared in advance, the process can go very, very quickly. Because there are going to be some posts that are going to be shorter than others. Some posts might be a video embed. Some posts might be just you commenting about the result of a case that came down. I've got one client who does that regularly. If a case comes down in his area, he'll write a small paragraph about it and post it to his blog. It's content, and it's meaningful to his business audience. The Wire. The Wire is social media and syndication. Lawyers are not good at social media, and there are a variety of reasons for that. Especially it really isn't just on the small or medium side. It's also on the large firm side. I mentioned before how large firms will just post, kind of fluffy information about charitable events that they've done. They'll post, what attorneys have joined the firm, and they're not really participating in any kind of social discussion on Facebook or Twitter, LinkedIn, etc. They might not even be blogging, which means that they don't have content that they can put onto their social media sites that speaks to, the people who are following them. I did a very, very informal study of my own a couple of years ago that I called Milwaukee Lawyers, The Sound of Social Media Silence. And what I did was I took all of the top firms I took the 130 firms that were listed in the U.S. News and World Report, top Milwaukee law firms. And I know that people who are on that list buy in to that opportunity. It's not like they're ranked or evaluated. They paid. But I used it as a way of getting out to these websites to evaluate what they were doing with social media. And I found out that 70% of that 130 had no social media site at all. I began to reflect. I wonder why that is. Are they worried, like I've seen in articles in other jurisdictions, about creating an attorney-client relationship or implying it? And I'm like, no, it's not that. It's the fact that they don't know what to do with those platforms, or they think that they're inconsequential to their business. And if you have a blog on your site and you're regularly updating it with information, these are great platforms to syndicate that content. You're not providing legal advice and information. In fact, there's probably a disclaimer at the bottom, we've all seen this, bottom of an article, bottom of a blog post. This does not constitute legal advice. It does not constitute an attorney-client relationship. It is perfect. It is for informational purposes only. It's the same way with social media. You're putting the information out there to be consumed by the public as a possibility or as a potential of them giving you a phone call and asking a question or bringing their case to you. The two areas that I think every law firm of whatever size should be focused on are email and Facebook, Twitter, LinkedIn. Those are your three options, and your blog starts the process because that's where you're going to be drawing your content from. So we can take a look at that real quick. We know that people are creatures of habit in terms of making recommendations to their friends. In fact, LexisNexis did a study that found that almost 14% of people found out about an attorney through a friend. Well, if you think about the Facebook environment, it's all about friends. It's all about people helping people and making recommendations. Same way with LinkedIn, professionals making recommendations to one another. That's why social media becomes important. And 84% of global respondents in Nielsen survey identified friends as the most trustworthy when making a purchasing decision. That's why email and social media matter, because they form natural opportunities for digital word-of-mouth marketing. Oh, I got an email from this guy who was my lawyer a couple of years back. You should take a read of this. It's interesting. I'm going to forward it on to you. Or, yeah, I follow this guy on LinkedIn who is my attorney, and he has some great posts about the kinds of business decisions you're making. You should check him out. You should follow him as well. These are all opportunities for marketing your firm. Now, in terms of choosing a platform to do this on, one size definitely doesn't fit all. And my choice of Facebook, Twitter, and LinkedIn is kind of a 10,000-foot view of where lawyers are currently. Facebook, I am the coolest on because there are certain law firms and practice areas that fit the Facebook community that people would be interested in following. There are others who aren't going to see any kind of leverage using Facebook because they simply aren't social content. For example, if your firm deals with esoteric tax issues or intellectual property issues, well, what's the likelihood that somebody's really going to be interested in seeing that after they've seen a grumpy cat meme? They're not looking for you to discuss changes to Section 809 of the Wisconsin tax code after they've watched a funny video of from the Daily Show or something like that. Facebook is a very, very casual environment that is more personal, and you really have to have a good strategy for using that platform. Yet, most law firms that do social went out to Facebook and created a page for themselves thinking, hey, this is where they all are. They'll come to us out here. I actually had clients back when Facebook kind of exploded in 07, 08 saying to me, we're thinking of shutting down the website, Pat. Why is that? It's like, because we got Facebook now. That's where they all are. There are nearly 1 billion people out there. It's like, what do we need to pay you for and have a website and everything? I'm like, are you serious? Really? You're going to trust your whole marketing and digital presence to Mark Zuckerberg and company at Facebook? It's like, these are outlets. They're not replacements for your website. It's a great place to syndicate the content from your blog and to connect with your audiences for digital word-of-mouth marketing, but that's about it. And you have to pick well. If you deal with esoteric areas of law, your best place is probably LinkedIn. Because the people who are on LinkedIn are there specifically for professional reasons. They're business people who are interested in those issues and can act upon the information you're providing. The average consumer on Facebook is not looking for that kind of content, nor are they expecting it. So any efforts that you put in on Facebook are kind of wasted. Twitter in the mix becomes just an easy way of syndicating your content out to another platform. It's not like you're relying upon Twitter for your entire social media presence. If you make a blog post, you can put it out on Twitter, and if people who are interested in that kind of material follow you, the more likely they are to read your material. So those are my three choices, and it is kind of a complicated decision that it's good to walk through in terms of your considerations. And the reason, one more final thing, and this is in your packets, you should really look at this. Social media marketing is much different than other forms of marketing, especially traditional marketing if you've done advertising or you've done some more aggressive things like writing op-eds or columns in your area of practice and expertise. There are stages of there are stages of consideration and types of materials that are used to nurture and create leads and opportunities in social space. This slide does a great job in identifying not only the materials that go into those stages for social media marketing, but also some great blog ideas that can be used to create easy, cheap content by your firm to speak to these various areas and to also make it easy for you to come up with things to write about each week, each month. So definitely take a look at that. And the whole thing, again, is that digital word of mouth marketing and moving them down the sales funnel to become a new client based upon what you've created. But always remember that all roads have to go back to your website for your social media marketing to succeed. People who do social well, the kinds of materials that they're putting out on their social media sites are all directing back into their domains, because once I have you there, I have you there. And I can offer you calls to action and other materials that you might not discover on social media. There's this tendency with social, kind of goes with, people saying, hey, we could replace our firm website with a social media channel like Facebook, where people will publish to Facebook first and it'll never make it to their website, which is just shooting yourself in the foot. If you don't have content on your website, what's Google going to suck up? Google doesn't index Facebook posts. Google also doesn't index tweets. So if you think that just by, posting articles or posting comments to a social media platform is enough, and you're not directing back to your site, then you're kind of defeating the whole purpose of social media from the get-go. Social media is great, but it is not really my favorite form of digital marketing. I am a very, very passionate proponent of email marketing. In fact, anybody here, show of hands, how many lawyers here or folks subscribe to Case Law Express here at the bar? One person? Two people? It's like, I created that service back, it was like 1999. And we had like 6,500 subscribers. I'm sure it's much, much larger now, but there was a reason for that. It's like the bar's central content at that point, this was way before the current website, was case law. And this email gave us a natural opportunity to put relevant case law in front of our attorneys, or you guys. And that kind of demonstrates the one-to-one relationship that email creates. Social media might be all the rage, but you're speaking to one anonymous audience in a one-way manner. They can like or share or comment or click on your links, but those are very, very weak measures for you in terms of understanding, what do people want me to write about? What are people interested in? Emails has always solved for that equation and was truly the first social media, because it's people talking to each other. With email marketing, you have all kinds of measures that you can use that are very easy to understand. Open and click-through rates, different activities and behaviors by users, how many people forwarded, 24-hour performance of your email, how many people looked at it within the first 24 hours and what did they do, what were the top links they clicked on, and so much more. You get none of that with social media at all. And you don't have any ability to segment your audiences either. If you were a general practice firm and you put out a newsletter and say you had one story from your blog for each of your primary practice areas. Those are segments. The people who click on those links are the people who are most interested in that kind of content. You don't get that with social media. You might get people liking it. You might get people clicking on it. It's a real roll of the dice. But people who subscribe to emails want your content. So to the extent that they've given you their permission to send you that information, take advantage of it and read your statistics to provide them more content that helps to build sales. This chart kind of describes it all, and I try to drive this home in every presentation that I do. It's like, email is an intentional subscription. You want and are interested in the kinds of content that's coming from a firm or a company, so you've provided them with your email address. Social media, it's active or passive following or both. Some people like things on Facebook. You may follow the pattern just because. I have lots of vanity likes that round out who I am as a person. And I don't care about those companies. I really don't care what's coming down the pike from them. There's just something about them, that says to my friends and family that, yeah, this kind of rounds out my kind of rock and roll lifestyle, and that's why I like it. That doesn't tell that company anything about me, whereas an email, I'm intentionally saying that I'm interested in you. With email, you get 100% deliverability. Meaning that all of the people on the list who have subscribed get your email. Whereas with social media, Facebook, if you have a Facebook page, only 8 to 10% of your audience is reached on every single post. And it's gone down, actually. It's now, I've seen studies where it's 4 to 5% of the posts that you put on social media now are filtered out of the news feed. And the reason why is Facebook wants you to buy advertising, wants you to boost your posts. It's kind of a lot of chutzpah, They give you this nice free service. Yeah, that's great and everything. But it took me a while to get those 400 likes on my page. I had an event, I had a conference, and that's where they came from. And I invested all that money to get those people to come to my Facebook page. And now you're telling me that I can only reach 4% of them? So, simple math. It's like 100, 4%. I reach 4 out of 100 until I pay you more. It's kind of insulting. And with Twitter, as a comparison, anybody who's on Twitter knows that most people follow dozens of sites on Twitter, and it's a buried and cluttered experience. I mean, you have to wade through tweet after tweet after tweet. Again, with email, it's popping into your inbox. Email, again, measurable, open rate, click-throughs. You can do A/B testing, where you send one email out to a certain group and another out to another group, and you see which performs better. One might have one story, one might have another story to gauge, what they're clicking on more. With Facebook, you can certainly do some measurement if you're doing advertising, same way with Twitter, but the statistics that they provide otherwise are virtually meaningless for small businesses because you don't have the large audiences that, say, a Coca-Cola does with like 3.8 million followers or 10 million followers. So when they post something, yeah, those statistics are meaningful. They can actually generate some conclusions from how many people shared, liked, or engaged with that kind of a content. For somebody who's only reaching 8 to 10% of their audience, they really can't make any conclusions. 2 people might have liked that post. 1 person might have shared it. 1 person might have left a comment. With email too, you have a high return on investment. The big scandal of social media is something that is terribly undercovered, which is marketers don't know how to measure it. And C-suite executives at large companies are demanding of their marketing departments, have for several years, you know, what are we getting out of this? I mean, we're seeing any kind of return on investment? And the marketers, some 52% of them, were saying, well, we really can't make any conclusions because it's not all that measurable. The measures are really, really weak. So we've seen in the last couple of years more large corporations reinvesting in email because of the high measurability and results that they achieve. A couple more things. Email, very low production cost and time expenditure. The average small business, though, spends 1 to 10 hours a week blogging and doing social media, and with very, very few results to show for. Email, again, you can segment your audience into different areas. Social media, one audience, period. You really don't have anything more than that. And email can be free or low cost. Social media is free, but as you can see, you get what you pay for. So the choice is kind of clear. And if that doesn't tell you, email is 40 times more effective than Facebook and Twitter in acquiring new customers because they've asked to have a relationship with you. They've asked to receive your communications. And 70% of internet users in a study by eMarketer admitted that email is their preferred method of communication with businesses. Don't get in the way of my social experience. Don't get in the way of my grandkids' pictures or, you know, my college friends' crazy posts, you know, from The Onion. It's like, that's why I'm on that platform. I'm not out there to get business communications. It's like, if you want to talk to me via email. And you want to talk about an ROI, 4,300%. For every dollar spent on email marketing, your firm is likely to generate an average of $38 of return on investment on that. And the reason should be clear. It's like the people who are subscribing to your e-news, if you're doing content well, are generally interested in your services. And they are more likely going to be your client, and the time will pay off. And if you want to get an idea about your other investments, both digital and analog, you can see that email outperforms them as well. And again, it's because of this one-to-one relationship. There are two providers for email if you're interested in going this route. One is called MailChimp. They have a forever free plan where you can have 2,000 email subscribers in their service. Everything is handled through the browser, much like WordPress. They have templates, few templates, you know, a dozen or so templates that you can use. You can put your logo into and send out communications, a newsletter, etc. If you're looking for something that's a bit more it's a bit more shadowed in terms of having help in the process, I'd suggest Constant Contact, which has been around longer than MailChimp and runs $20 a month for 500 contacts, which for a solo or a small firm probably is in the ballpark of how many subscribers you would have, and they have 400 drag and drop templates on board with their service, and they offer live operator support, which is really nice. And I've actually done that live operator support with a couple of clients, and it's excellent. They offer a 60-day free trial as well that has live operator support. So if you're looking to kick the tires on email marketing and see how Constant Contact works, you can have, you know, a shadow in the process who can show you the best of the service. And finally, the hook. What is all of this about? What this is all about is the goal of all marketing, which is top of mind recognition. The reason you see as many ads on television, the reason you see billboards and ads in magazines is intentional. They want you to remember that company when you have that need. And in terms of digital word of mouth, that's what's critical, is the fact that if you do things well on your blog, on your firm website, in your social media, you are creating word of mouth opportunities. You're also creating things like client reliance. They're not going to go to another firm because you're their go-to. Also creates greater networking opportunities, greater media opportunities if you're in that industry, and if you do any kind of presenting or speaking, if you show yourself to be a thought leader on your blog and in social media, you'll catch the attention of people who are looking for somebody to speak at a conference like this, somebody to speak at a national or an international conference, and I've seen it happen. I've seen people who were authorities in their field or their expertise end up as kind of superstars for the amount of effort that they put into their websites and their writing and social media work. And it takes some time, but it's worth it in the end. If you still need help, there's my contact information, and love to talk to you. Any questions at all? Yes, sir.
Pat, from the web, a viewer says he hears colleagues occasionally talking about paying a fee to get on the top of a Google search. Is that worth it, or is that just another scam to get my money?
Likely a scam. The top spots on Google are incredibly expensive, and they're tied to paid opportunities through Google, as are the AdWords boxes that you see down the side of the organic search results that are pulled up. People are paying per click on those ads, and those clicks can be extremely expensive. I did a campaign with Google AdWords for an international adoption attorney, and we were paying $38 a click. $38 a click. With no guarantee, by the way, that those clicks are actually live human beings. They could be bots that are coming in and clicking for whatever reason. So stay away from those folks. Also stay away from SEO consultants who can promise you first page on Google. That's also a scam. And if you get into bed with a search engine optimization firm, be sure you know what they're providing. Lots of places take advantage of the fact that lots of small business people don't understand how the web works or don't understand web technologies or search engine optimization, and they'll say, we'll get you there, and they cut a check, and the money goes out, and they really don't see any results. Just to kind of flip the cards here, there are over 500 variables in Google's algorithm. We think, and it's changing every day, because that's what they do, and they're a publicly traded company. They have a fiduciary responsibility to continue to be the best search engine in the world for their shareholders. And merely gaming keywords and headlines or adding keywords into copy is not going to rocket you to the front page of Google. There are about 50 of those variables that we kind of know. 10 have been fessed up to by Google, but the rest are a great mystery. The other thing, too, to keep in mind, and this is something that's fresh, that's happened within the last couple of weeks, Google is building a specific search engine for mobile to capitalize on the fact that most of us use mobile search now to locate businesses. And when you pull up something in mobile, maybe you just type in a keyword, pizza, Madison, and you get a map, and you have 3, what they call the hamburger stack of results. Here are the 3 pizza parlors that Google is providing you. Why are they providing those 3? Lots of reasons, but they're not going to tell you. So if a firm comes up to you and says, yeah, I can get you into those 3, send them walking. It's like, unless they work for Google, you know, and they're giving you that information. And if that's the case, please send them to me. I'd like to talk to that person, take them out to dinner, you know. But yeah. Any other questions? Well, thank you very much.
All right, thanks, Pat. Well, that concludes the seminar. Just a reminder, if you could, please fill out your evaluation forms and drop them on the front desk for us. We appreciate that. Web viewers, you will get that by email. And thank you all for coming. Appreciate it very much.